Judge Walker heard this, and in July of 2006 said, you know, I don't think this thing's much of a secret anymore, by the way. You guys are going on national television talking about how great it is. So I think that we should go forward. There may be pieces of evidence in the case that have to be excluded because they are state secrets, but they've got a threshold case here. And by the way, our threshold case, Mr. Klein is not a classified or cleared person. The documents he gave us are not classified documents. All of the evidence that I have just explained to you, not declared secret by the government. In fact, the first thing that happened in the case is that they asked us to see all these documents. They said they thought it might be classified information. They kept them for a week, and they came back to me, and they said, none of this is classified. So we can talk about all of what we know so far here. And so Judge Walker said, look, they've got a story here to tell without classified information, and they deserve the right to be able to tell it and for us to be able to evaluate it. That decision went up to the Ninth Circuit Court of Appeals, which is the next Court of Appeals, and it was heard in August of 2008. Perhaps because that argument didn't go as well as the government had hoped, immediately there was a push in Congress to grant retroactive immunity to the phone companies. Retroactive immunity was a big fight. You may remember Senator Chris Dodd, who was running for president, offering to and then ultimately filibustering it. You may remember that then Senator Obama said he would filibuster it. Then as he got closer to being president of the United States, decided to actually vote for it. A fight that went on for about 9 months, and ultimately we lost the fight, and a bill giving the president the right to grant retroactive immunity to the phone companies was passed in July of 2009. We are in the midst of fighting that. I think it's unconstitutional. I don't think Congress gets to hand the executive the right to throw cases out of the judicial branch. I think that's a separation of powers problems in about 3 different ways, actually. So that has been presented to Judge Walker, and we're currently waiting for his decision on that fight. But in the meantime, my organization wanted to get back to what it is we thought we were doing to begin with, which is to stop the spying. So in order to do that, and during the midst of the congressional fight about immunity for the phone companies, many members of Congress and the administration said, well, don't worry, EFF. If you can't sue the phone companies, you can still sue the government. Why don't you just sue the government directly for this thing you said that happened that we don't think happened, but anyway might be legal even if it did? And I said, okay. So in September, we brought a suit against the federal government for the same allegations, the dragnet wiretapping and the data mining that Mr. Klein brought to us, and the wiretapping for all of it. And we also named some Bush administration officials who had been involved in implementing this. We decided after the government asked us, because this was in September, to wait until after the election before the case got going in earnest. We decided to do so because Mr. Obama was campaigning on the idea that he was going to bring about more transparency, less government secrecy, and a return to the rule of law, and we thought that all sounds really good. Let's see what happens. So as you know, Mr. Obama was elected. We gave them until April of this year before they had to respond to the case. They filed their first papers in the first week of April, and lo and behold, those papers are worse than anything we saw from the Bush administration. They claim the same broad state secrecy arguments. They claim sovereign immunity. And they make an actually even broader claim in sovereign immunity than anything we ever saw from the Bush administration. They're essentially arguing that the government can never be sued for illegally wiretapping anyone in violation of federal statutes. The only thing the government can ever be sued for is improperly disclosing something that they wiretapped illegally. This would eviscerate, as I said, almost 100 years worth of protections for your communications. And again, now it may be that nobody ever asked the Bush administration this question, but we never got this answer from the Bush administration. So it was incredibly sad for us to read those papers and to see them taking this broad position, because their argument about sovereign immunity doesn't just apply in terrorism cases. And it doesn't just apply in cases involving national security. This is an argument that no claim of illegal wiretapping, even in an ordinary run-of-the-mill domestic case, could ever be brought claiming violation of federal law. And we think that's a tremendously scary and overbroad interpretation, and we hope somebody just goofed in making it, but so far not. So that's where we are with the lawsuits right now. Now, let me tell you a little bit, kind of get to the fun part, what I think is at stake in these fights, because I think there are several important things at stake in these fights. The first thing I think, and because my organization is fundamentally a privacy and free speech organization, is the people's right to privacy in their everyday communications. The Fourth Amendment was written in a specific context at the time that this country was founded, and the specific context had to do with something that then King George was issuing, which were called general warrants, or writs of assistance. And this was the idea that the president could issue a general warrant, a warrant that said a crime is committed, these people aren't paying taxes, somebody isn't paying taxes on their tea. Tea importation was a big issue at the time of Revolution. And with this general authority that some crime had been committed by someone, the king's men were authorized to rifle through everybody's communications and to search everyone's houses in case you might have violated the law. And I think that what's going on now with the government getting access to everybody's communications and filtering through them, just in case you may have sent something that violates the law, is a return to general warrants. And in fact, it's a return to a much more dangerous form of general warrants than we ever saw in revolutionary times, because the king's men couldn't search everyone's house. But those computers can search everyone's communications and can filter them. So I think there's a tremendous issue in the Fourth Amendment, and one of the founding issues of our country. And you can read, there are plenty of historical evidence that talk about general warrants and writs of assistance and how these were one of the key reasons that the colonists decided that they needed to break out on their own and write a Fourth Amendment that required individualized suspicion and careful particularity of what was being searched beforehand. We seem to have thrown this out the window without anybody ever talking about it. We are also throwing out federal law. Federal law basically requires that your phone companies handle your communications and only for purposes of delivering them. And the minute that they do something with your communications other than provide you service or protect their own networks from fraud, they're violating federal law. And certainly wholesalely handing over all of your communications and communications records to the NSA is not within the rubric of simply providing you the service. And so we think they violated federal laws. The other thing that concerns us about privacy is really something kind of that we know from history, which is, and I'm from Iowa, so this is one of my favorite quotes, if you build it, they will come. If you start out with something that's only supposed to be about terrorists, it's not going to stay just about terrorists. We're beginning to see this already in all of the other Bush administration things. We're seeing them turned against protesters. We're seeing them turned against journalists. We're beginning to see, kind of slowly what's happened to these big powers that the government granted itself after 9/11. And I just think that once we build one of these systems where we can use it for one particular system, it is inevitable that it's going to be used for other systems and for other sorts of problems that the government is concerned about, not all of which those of us who are citizens would agree with. And when you combine that with the tremendous level of government secrecy that is going to go on around these situations, I think it's a recipe for disaster for our country. The next thing I think that is at stake is the questions of executive authority and separations of powers. There are fundamental questions about how we run our country going through this discussion. Can the executive ignore laws that have been passed by Congress? Can the executive demand that the courts refuse to consider questions of the constitutional rights of millions of ordinary Americans? Can the executive be given the right to decide which law applies in a particular case, which is really what's going on in the immunity fight? What Congress passed wasn't retroactive immunity for the phone companies. It was giving the executive to decide that either the regular FISA laws applied or you're going to get out of jail free card. And the executive has complete discretion which one of those choices to make. That's actually choosing which law applies to which case, and there's no limits on the executive's discretion in that law. And I think that's a fundamental question of separation of powers and executive authority. And finally, it's a question of due process. If we are all being surveilled, do we have the right to go to court and ask for it to be stopped or not? Are we going to be able to detect mistakes and misuse of this huge system that's been built at taxpayer expense?